Okay, let's wrap up our discussion of the Supreme Court by looking at some factors that influence the decision that the court makes. Number one is precedent, and the idea of stare decisis. Stare decisis is Latin for let the decision stand, and it goes with this idea of precedent, of what has come before, what decisions have the courts made. They like to be consistent. With precedent, you're operating under the jurisdiction of common law. You're looking at all the previous case histories that have happened in our country and balancing that against what is currently before the court. There's very strong reluctance on the part of the court for moving forward and changing things radically. If you look at no further than the example of Plessy v. Ferguson, which set the doctrine of separate but equal facilities when dealing with race. It took a long time for us to get from Plessy to Brown v. Board, which said that separate was inherently unequal. It's because there's a strong reliance on the court for precedent. You could also look at the case of Roe v. Wade in 1973, setting the precedent that women has their constitutional right to choose to have an abortion. And while there's been conservative majorities on the court since then, they have chipped away at some of the powers of Roe and some of the influence of Roe, but they have not overturned that decision. That's because precedent matters. There is a desire to have a consistency to the court. Now, another thing that influences the decision is the judges themselves, and what is their philosophy? Are they activists? Do they see themselves in the role of making law? With the Brown decision, that is a very activist decision. What they looked at doing with Brown v. Board is they said every school in the country needs to desegregate. That is making law. That is dictating to the people and to the government what they need to do. Now, embedded in this activism is this idea of, are you a liberal or are you conservative? There is activism on both sides. When liberals try to push the Constitution, open the bounds of the Constitution, they are being activist on their side. When judges want to rein in Congress in a conservative manner, when they look to strike down the use of the Commerce Clause, like the court did in U.S. v. Lopez, overturning the Gun-Free School Zone Act, that's an activist approach from the conservative side. On the other hand, there's the restraint argument. There is this idea that judges are there kind of as a referee. You just look and call foul if something has gone wrong. So that's a philosophy comes into play when the decisions are being made. Then they also have to consider Congress and the president. What are they going to react? How are they going to react to this? Remember, Congress has the power to reorganize the court system. They can add judges to the courts. They can change the composure of the lower courts. They can change up how the district and appellate courts look to kind of chip away at Supreme Court power. And they can change laws. If the Supreme Court strikes down a law of Congress, they can go right back and pass it again. Or, if the court says that something Congress does is unconstitutional, Congress does have the power to amend the Constitution and give themselves that power. Then remember that the president, the executive, the bureaucracy, have to carry out these decisions. And sometimes presidents can ignore these actions. That also happens at the level of governor, too. Governors tend to ignore the actions of the Supreme Court, especially Brown v. Board. That was not a popular decision nationwide, and the court had to come back and tell the states to actually go through and carry out the decision. So those are some limits on judicial power and something that they have to consider. And lastly, they consider public opinion. They are not elected. They cannot be removed from office unless they're impeached. They serve life terms, so they are insulated from public opinion. But they are very aware of the public's sentiment. I think a great example of that is the Roberts Court and their decision on the Obama healthcare initiative. They were very keenly aware, especially Chief Justice Roberts, who authored the decision, who was the critical vote that made the outcome the way it was. He was keenly aware of the view of the court in public opinion, that they had become too politicized, that the conservatives were just handing down decisions to please their Republican base. And so keeping that in mind, that influenced a little bit of how the decision was written, crafted, and the ultimate factors that went into deciding to uphold Obamacare as a legitimate constitutional law.